Hi, everyone. Welcome and thank you so much for joining us this evening. My name is Maria Walgen and I'm the Executive Director of the Young Center for Immigrant Children's Rights. We are so thrilled to announce our new initiative, which we have called Reimagining Children's Immigration Proceedings. And this is an entirely new system which is centered on children. We hatched this idea years ago. It was Jennifer Nagda, Elizabeth Frankel, and me. And our goal was really to bring together immigration practitioners with the experts in child welfare, juvenile justice, and child development to learn from them and to work with them to reimagine what a system for immigrant children could look like if we built one from scratch, rather than trying to fix a system that was designed for adults. But I want to back up for a minute and start by recognizing all of the advocates who have fought incredibly heroic battles to win protections for immigrant kids over the last decades. Together, we've really accomplished a lot. Asylum interviews instead of adversarial court hearings, independent child advocates to advocate for best interest, safe repatriation language, and so much more. But in the absence of an entire system for kids, those hard-won protections can be eliminated at a moment's notice, as this administration has proven again and again. So we decided to launch this Reimagining initiative now because I think we're at a special point in time. Well, we are at a special point in time at what we hope is near the end of this administration, when we have the momentum to start swinging the pendulum back. Because the last 4 years have shown what happens when you don't create systems around children and when enforcement authorities are not required to consider children's best interests, especially their safety and their need to be with family. Just even today, hundreds of kids remain separated from parents who were taken away from them more than 2 years ago. Tens of thousands of families are trapped along the border, living in tent cities, really refugee camps of our own making, waiting for hearings in US immigration courts. And close to 10,000 kids have been turned away at the border, sent back to their home countries without a single question asked. Where are your parents? Who do you live with? Are you afraid to return? So how did this project begin? Well, in 2016, with funding from the John D. and Catherine T. MacArthur Foundation, we brought together experts in child welfare, juvenile justice, child health, and development, as well as folks from the international immigration world and people from our domestic immigration world. We had practitioners, professors, current and former government officials, policy advocates, and former unaccompanied youth around the table. And for 2 days, we briefed each other on our different systems for making decisions about children's legal rights. It was a very candid, honest discussion, and we covered the good, the bad, and the really bad. I will say that the child welfare, juvenile justice, and child development people around the table were absolutely shocked when we told them about how children are treated in the immigration system. It made us feel better that we weren't imagining things. So that conversation became a jumping off point for lessons we could apply to building a new system for immigrant kids. We convened that symposium in September of 2016. It was 6 weeks before the election. And as you would no doubt guess, we then had to shift our focus to defending existing protections in law and policy. So you're going to hear more about the roadmap, but just a couple of the highlights that I wanted to point out. So right now, and it has been this way as long as I've been doing this work, kids are held in custody for months, even if they have family in the US. But in the child welfare system, on the other hand, children are placed with relatives in a matter of days. So in the Reimagining report, we envision shortening the time to days or weeks of custody. This change is really common sense. We need to prioritize getting kids back to their families where they feel safe, where they feel loved, before commencing the legal process. So in other words, dividing those two, working really hard to get the kids out of custody and then beginning the legal process. Second, no surprise, children's best interest would be a primary consideration in every decision. I'm sure all of you know this principle is enshrined in international law, in the laws of all 50 states, but immigrant children are left out when it comes to an absolute requirement to consider best interests, and we aim to remedy that. And today, children are deported with no assessment of whether they'll be safe. And under the Reimagine system, and right now today, I mean, the burden is on the child to prove that they have a right to stay here, that they would be in jeopardy if they went back. So under the Reimagine system, it would be the government's burden to prove the children would be safe. And then even more, there would be a new form of protection for children who would be at risk but don't fall within the other categories of protection, and it would be called best interest protective status. And there's so much more which Jennifer Nagda is going to tell you about. Will there be challenges to implementation? Of course. Implementation is really, that's the hard part. It's going to require the government to think differently about how it allocates money, from dismantling many programs built around custody and moving those funds to support children in the community where they are released to their families. It will require funds to train a dedicated group of judges and attorneys. It'll require funds to provide attorneys to all children who need them. And it absolutely will require changes in law, regulation, and policy. I'm not saying it'll be easy, it certainly won't, but it doesn't all need to be done at once. The various elements of the reimagining roadmap can be tiered so that Congress tackles the separation of custody and legal cases first while we work on developing a new legal process over a longer period of time. I want to thank everyone who was involved in the symposium, who gave their brilliant ideas, who argued with us, who edited and gave feedback, especially positive feedback. Those of you who wrote commentaries, thank you so very much. Okay, so here's what we have planned for tonight. My colleague Jennifer Nagda is going to dive into a few more details about the report, and then we've invited the perspective of people who know the system inside and out. We have several people who are going to speak this evening. We have Elvis Garcia Callejas, Elvis is a member of the Young Center Board of Directors. He's an advocate for youth who participated in the Chicago Symposium and also wrote a commentary that is published as part of the report. Then we have Gladys Molina Alt, who has more than a decade of experience fighting for immigrant children, both as their direct representation attorney and now as the director of the Young Center's Child Advocate Program. Gladys is going to share her perspective on how she thinks the recommendations will benefit children and the attorneys who represent them. But first, we're going to hear from Tara Magner. Tara has been a friend of the Young Center and the role of child advocates for more than a decade. While Tara was senior counsel to Senator Leahy, who at that time chaired the Senate Judiciary Committee, she worked on the anti-trafficking law that provides for independent child advocates and contains that all-important term, best interests. When Tara then joined the MacArthur Foundation, she was part of the immigration team, and Tara is responsible for so much of the work on unaccompanied children's issues by organizations across the country over the last many years. Tara is now the director of the Chicago Commitment at the MacArthur Foundation, where the focus is on communities, arts, and organizations in Chicago. We are just incredibly grateful to Tara and to the MacArthur Foundation for supporting this project. So I'm going to turn it over to you now, Tara.
Thank you, Maria, and thank you to the Young Center for including me in the release of this incredibly important roadmap. It demonstrates how to achieve genuine protection for children in immigration proceedings. The Young Center asked me to say a few words about why the MacArthur Foundation funded this endeavor. The fundamental reason is the belief that children in US immigration proceedings must be recognized and protected first and foremost as children. Secondly, we were impressed by the Young Center's incredible track record in developing policy and practice hand in hand with government officials, immigration judges, and lawyers representing the children, developing practice guidance that was adopted and implemented by those officials, all of which have enhanced protections for children. In the roadmap, you'll see a list of achievements that is long and very impressive. Maria just noted a few of them. But that list, as she also noted, is not complete. It is time to reimagine the system. So I hope that all of you will continue to work with and support the Young Center as it leads this work and paves the way toward achieving full protection for immigrant children. Thank you so much.
Thanks so much, Tara. Now it's my pleasure to introduce Jennifer Nagda. Jennifer is the director of our policy program. Jennifer is incredibly humble, but she is responsible for this initiative and the Reimagining Report. Jennifer took the germ of an idea and she never gave up. She gathered together an amazing group of colleagues from so many disciplines to brainstorm, hash out ideas, and then with those recommendations in hand, Jennifer did all of the hard work of putting together the roadmap that is the Reimagining Report. So thank you so much, Jennifer, and I'm turning it over to you now.
Thanks, Maria. I appreciate that. And what we'll do for just a few minutes is really walk through some of the key recommendations of the report before we hear from both Elvis and Gladys. So the premise behind this report is the idea that reforming immigration law and policy shouldn't happen in a vacuum, but build on lessons learned, really hard-fought battles in other fields. So for example, in child welfare proceedings, it was common for children to be taken from their homes at the very first allegation of abuse or neglect. Whether or not these allegations were ultimately founded, children could spend months or even years separated from parents and family with immeasurable damage to their well-being. But in 2018, advocates persuaded Congress to pass the Family First Prevention Services Act. It's a law that recognizes the importance of family for children and which creates financial incentives for states to keep vulnerable children with their families in homes and address concerns about mental health and substance abuse by providing services to the entire family, allowing children to remain in their community. While state child welfare systems remain far from perfect, and many lack the safeguards needed to prevent disproportionate and dangerous state intervention, particularly in families of color, advocates have changed federal law to advance proven evidence-based practices that benefit vulnerable kids. Similarly, cities like Chicago have created models of providing services in the community for children charged with delinquency. Youth incarceration rates have dropped substantially over the last several years, and community-based programs that provide the right amount of support have been proven to provide safe and effective alternatives to detention. Yet in the federal immigration realm, we've moved in the opposite direction, building up a system of detention-based services for children that are often used to keep children in custody for months and even years, and which allow the government to gather and then share children's personal information in ways that harm children, such as the arrest and deportation of family members. So our Reimagining Report starts with lessons we learned in these consultations with experts outside of our field. Many of these ideas are fundamental to other systems where children's rights are at stake, but the concepts are really foreign to the way in which immigrant children are treated. And these concepts include, first, the idea of best interest that Maria mentioned. We've made tremendous progress over the last 17 years. Immigration judges, asylum officers, government officials ask for best interest recommendations. But as essential as the concept may seem, immigration officials are not required to consider the best interest of the child in every decision. We would change that. Second is prioritizing safety and family. Detention and separation is traumatizing for kids. Detention is an incredibly hard place to tell your story and to build trust with your attorney or your advocate. The third concept is just fair hearings for children. This means legal processes that are tailored to children's age and stages of development, and ensuring that they never navigate a legal case alone, unrepresented. The fourth idea is specialization. Not everyone can and should work on kids' cases, and those who do should have regular training on child health and development, but also specific aspects of children's migration journeys, including attention to race, gender, and other aspects of identity. Fifth is the idea that childhood doesn't end the day you turn 18. Our work with child development experts brought much greater attention to the concept of emerging adulthood, which extends far beyond 18 into young people's mid-20s. Sixth is the idea that we don't put children in harm's way. Government shouldn't perpetrate harm against children, but this happens all the time in immigration law where children lose cases because the harm they experienced doesn't meet the very specific definition of asylum or other forms of legal protection. Under the roadmap, children who face harm upon return cannot be removed. And finally, advocates consistently pushed us to develop a process that would be available to all children, not just unaccompanied and separated children, but any immigrant child who does not yet have status. That in particular will make implementation of this roadmap a challenge, but as Maria mentioned, it's a really necessary one. Those themes and lessons are described in part 1 of the report, but you can also find them in part 4, where an incredible group of experts, including a former INS official, a former unaccompanied youth, a forensic clinical psychologist who was part of the effort to end juvenile life without parole, all offer their perspectives on these issues. For the remaining couple of minutes, I want to talk about the process we recommend in the report, our roadmap for change. It has 3 central components. And the first is custody. So our report started back in 2016 with a particular focus on unaccompanied children, those who arrive at the border without a parent. But many children arrive with trusted siblings, grandparents, aunts and uncles, people who've cared for the children for years. Under current law, those children are separated and designated as unaccompanied. That separation provides the children with critical legal protections that go along with unaccompanied status. They can't be immediately deported. They have the right to appear before an immigration judge, but they suffer the trauma of separation. The roadmap rejects this distribution of benefits based on who happens to accompany the child. Instead, all children would and could be screened at the border by qualified independent experts to determine if the non-parent adults found with a child pose a risk of trafficking or immediate danger. In fact, there's already a bill in Congress that proposes a similar idea for children accompanied by parents. But only those children who are truly alone or truly at risk would end up in government custody under the roadmap. And all children, unaccompanied or otherwise, would access the same legal process and protections so that separation from trusted adults would no longer be necessary just to get children a fair day in court. For children who do come into custody, we need radical change. Children should not be in government custody for months and years. It should be days, maybe weeks. Experts in child welfare know how to screen children and family members for safety concerns and to do it safely and quickly. Children who need services will get those services, but in the community. Organizations who provide critical services to kids will still do so, but in the community rather in detention settings. Children who don't have family to welcome them also have a right to be in the least restrictive placement, which is foster care or small group settings in the community. No children should be in 100-bed buildings or former Walmarts with beds for 1,400 children, as we have in the Valley in Texas. Most importantly, children will not start their legal case while they're in custody. Children need to focus on safety and reunification with family first. Once there, they can start the process of meeting with a lawyer and developing their case. Any information gathered about the child during the custody process, including records from counseling sessions, have to be protected from use against the child in their case. So then we turn to the legal process, and I can't cover it in detail in just a couple of minutes, but I want to make a couple of points. Our process in the roadmap starts and ends in a conference room, not a courtroom, building off the model deployed in many family and some youth justice courts. The child is appointed a presiding judge who will navigate the case from start to finish. Next, an attorney, appointed by the government if needed, works with the child to submit a consolidated application for all forms of relief for which the child might be eligible. With guaranteed counsel for children, attorneys no longer have to play gatekeeper. They can instead focus on finding ways to advance arguments that children's experience render them eligible for protection. In the next phase, government officials review these paper-based applications. We had a lot of debate as to whether the presiding judge should review each claim brought by the child, or whether claims for asylum and special immigrant juvenile status and trafficking protection should, like they are now, be sent to other agencies with particular expertise. We saw the merits of both positions and there was a lot of debate, but ultimately we settled on a model where each claim is sent to the real experts in that subject, which allows for greater specialization and attention to the unique claims of children. Up to this point, the child will have spoken with the presiding judge at the conference and submit written testimony with their attorney as part of the application process. But the child won't have been forced to testify, and they won't need to unless any of the individual decision makers have questions for the child. When that happens, the questioning will follow the forensic interview model of child advocacy centers. Instead of repeated interviews with various government attorneys trained in cross-examination for adults, the questions will be consolidated, asked in that conference room by that same supervising presiding judge. The interview can be recorded and shared digitally with each of the other decision makers before they decide whether the child is eligible for relief. This entire process should take around 18 months, which is a far cry from the 3 to 5 years that may be needed right now due to court backlogs because children's cases are mixed up with adults. 18 months is also far longer than recent attorneys general would have it, who've proposed policies that would rush children's cases through rocket dockets so that they're deported while they're still in detention before even filing a claim. Without question, I think what we like most about the roadmap is the process that we propose for children who don't win a traditional claim of asylum or trafficking, but who are afraid of return. As I said before, today those children are ordered removed without another question asked, even if there's evidence in the record that they'd returned to an abuser, to homelessness, or to a persecutor. The roadmap turns current immigration law upside down and moves the burden off of the child and back to the government so that the government has to prove that the child will be safe upon return. The government can meet this burden by finding evidence that a parent or traditional caregiver is available and willing to care for the child. A judge would be able to order the child's return. And this may be the case for children who come hoping for a better life, but who aren't unsafe in their countries. But if the government can't meet this burden before the judge who's been watching the child's case, sat at the table with the child, read the child's various applications for protection, then the child can't be returned. And we call this new benefit best interest protective status. It would afford the child the right to remain in the country to adulthood, with the ability not just to go to school, but to work and have the threat of deportation removed. And adulthood means age 21. The details are the part that matter. I recognize that, and you can find those, should you choose to, in part 3 of this very long report. But you can also find it summarized in the executive summary and in a graphic that we created, which is on page 11 of the report, and which my colleagues will post to the chat box. I want to end here with the idea that we included at the end of the report itself, and that's this. Systems reform doesn't happen overnight. The roadmap will require significant changes in law, in regulation, and in policies, and everyone with responsibility for immigrant children will need to change their practices. The work of undoing the cruel practices of this particular administration, family separation, banishment, complete closure of the border, is different from that of imagining and creating a system in which children are cared for because they're children. We need to undertake both endeavors. To push the pendulum away from policies that are grounded in racism and classism and cruelty, we need a commitment to wholesale change. We don't have to start from scratch. There are such valuable lessons to learn from our colleagues who've worked for decades in child welfare, youth justice, domestic court, and child development. That's what we've attempted to capture here. Our hope is that the roadmap inspires further dialogue, engagement, and a commitment to the really hard work of creating the system that children deserve.
Thank you, Jennifer. Thanks so much. So it's now my pleasure to introduce Elvis Garcia Callejas. And Elvis, as I mentioned earlier, is a lifelong advocate for young people and has worked at various organizations serving unaccompanied kids. I mentioned it earlier, but Elvis is also a Young Center board member, and we are so grateful for his time and his perspective. So Elvis, I'm turning it over to you.
Thank you so much, Maria. Hello, everyone. First, I would like to thank the Young Center for giving me the opportunity to speak at this panel. I will also like to thank the MacArthur Foundation for all the help they have provided to the Young Center to come up with this report. I am very happy to be part of this panel. I actually participated in the Chicago Symposium back in September 2016, and I am happy to see that the report is now public. I was very impressed by every individual that attended that symposium and all the work that the Young Center has done and continue to do on behalf of an unaccompanied minor. I wrote a commentary for the final report about my personal experience going through the system 15 years ago, and my experience working with an accompanied minor for the last 7 years at Catholic Charities in New York and at NIJC in Chicago. For the people who do not know me, I came to the United States as an accompanied minor back in 2005 when I was 15 years old. I crossed the border and ended up at Annunciation House in El Paso, Texas. Annunciation House is a shelter that welcomes immigrants in El Paso. And while I was living in Annunciation House, I met an American family who agreed to take care of me and bring me to live with them to Chicago. While I was waiting to be reunified to be going live with the family, I was picked up by CBP, and I ended up in OR facilities. This is how I ended up in deportation proceedings. For this discussion, I agreed to offer observation from my perspective of the youth experience, government custody, and immigration court. There are 3 recommendations that I would like to talk about today. First, we must change the way we welcome children seeking protection in the United States. I am sure you have seen in the news the way kids have been separated from their family members and how they have been put in cages. The way we treat people who arrive in the United States is inhumane, it is cruel, and disrespectful. This is not how we should treat immigrants or refugee children. In my commentary that I wrote for the report, I wrote about what happened to me at the border when I encountered Customs and Border Patrol. I believe children should not be in CBP custody because CBP facilities are not appropriate for children. Officers are not trained on how to deal with children. During my time at CBP, I was treated like a criminal. I felt that I was being interrogated anytime that I was speaking to a CBP officer, and they even put me in handcuffs when I was transferred from CBP custody to ORR. I felt humiliated. This was the first time I have been in handcuffs. The conditions in CBP facilities are poor. Facilities are so cold that we have referred to them as ice boxes because of the low temperatures. CBP does not feed people very well. I was given cold frozen food, and it was even difficult to eat. The facilities are big warehouses, and they look and feel like jails. This is why I believe that children should not be in the custody of CBP. Another thing that I believe that is extremely important is for children to have an attorney when they are interacting with any CBP officers. When I was at CBP custody, they asked me to sign a document, which I did not understand. Luckily, I had spoken to other people that have advised me not to sign any document that will be given to me by CBP. I was given this document in English, and it was really hard for me to understand. Many kids who arrive at the border today do not know how to read or to write. Many of the children that are arriving at the border today are indigenous children that they don't even know how to speak Spanish. I cannot imagine how difficult it must be for them to go through this process. Second, I think that children spent in government custody should be as short as possible. It doesn't matter how good facilities are. It is traumatic for young people to be detained. I was detained for 49 days in a large shelter that had about 100 kids, boys and girls of all ages. We were kids from all over Latin America. I was confused on how that shelter decided which kids were reunified with their family members, which kids had to go back to their home country, and which kids had to stay in the facility. I remember this kid, Elmer, from Honduras, who had been detained for 6 months. He was picked up by CBP. He was picked up by ICE one day, and I didn't understand why he had been taken away. When I asked why Elmer was taken away, they told me that he had turned 18 years old and he had to go into adult detention. This made all the kids that were 17 years old that were about to turn 18 really scared. And I was really worried about my friend that had been taken by ICE. There were also 2 Mexican girls that had been detained for 2 years. I did not understand why these 2 girls had been detained for such a long time. The only thing that I knew is that they could not go back to their home country because their life was at risk. At night, I would cry with the other kids in my room. We were frustrated of being detained for such a long time, and at times we talk about giving up our cases and just escape from the shelter. Finally, I would like to recommend that children should have an attorney to guide them through the whole process. Having a lawyer is a key for a child to win his or her case. I had my first hearing while I was detaining ORR, and it was very confusing because I didn't understand the importance of this hearing. I went to court with a group of kids, and in front of us, there was a judge who was in charge of this side of the case. There was an attorney representing the government, and his job was to return people to their home country, and an interpreter. The judge called us one by one and asked us questions. This was in a very formal setting. When it was my turn, I didn't understand what the interpreter was saying, and the only thing that I knew was that I needed more time to continue with my case. Every phone call that I had with my American family, I would tell them to do everything as possible to take me out of there, of our shelter. The children who are detained are going through a lot of difficulties while they are in detention. It is hard to follow every single movement that you do, and it's something that children shouldn't be in detention. Although my experience ended up with very good positive outcome, I was continually confused about what was happening. The remaining report shows that we need to change the entire system. I realized that this won't happen right away, but we need to start changing things as soon as possible to make the life of children better. Thank you so much for your time.
Thanks so much, Elvis. We really appreciate it. I'm now happy to introduce Gladys Molina. I have known Gladys from the early days of the Young Center when she was at ProBar in Harlingen, Texas, which for those of you who don't know is on the border. Gladys and I worked together on one of our first Harlingen cases. It was a really difficult case involving a toddler separated from his mother and then his mother later deported. We also worked together when Gladys was at the Florence Project in Arizona and at KIND, at Kids in Need of Defense. And we're just so thrilled that Gladys is now the director of our Child Advocate Program and oversees more than 60 people in 8 locations who advocate their hearts out every day for the kids they serve. So Gladys, I'm turning it over to you.
Thank you, Maria. To piggyback on what Elvis said, I will also like to express my gratitude to our leadership at the Young Center for seeing this idea through, and to the MacArthur Foundation for giving us the support to get this report completed. I will offer my humble observations as an attorney that for the first 10 years of my career, I represented unaccompanied kids in immigration proceedings in Harlingen and California and later Arizona. And also from my perspective of working at the Young Center within the Child Advocate Program for the almost now 5 years. So that's where my reflections are coming from. And one of the first reflections I have about this reimagined system is how it envisions to uphold the sanctity of childhood, whereby we put the interests of children at the center of proceedings, as opposed to the interest of governmental interests to deter immigration at any cost, including family separation, the interest of detention, and the interest of removal, again, at any cost, even if that means sending a child back to unsafe conditions. And we need such a system. We need a system that focuses on children, that is centered on that, and that's the central inquiry. It is what is best for children, not what is best for the deterring immigration. It also upholds the importance of every child, whether they be immigrant or not, undergoing immigration proceedings or not, is that it sees children as having fundamental needs to be with their parents, caregivers, and to be in safe places before we begin to question them or put them through a stressful legal proceeding. And it honors them as children, such as mine or any other parents. And it creates a system where we're willing to look at the complexities of each child and recognize that each child is cherishable and deserving of dignity along a process that they go through. That somehow immigrant children are not a class for whom we have to fight hard for basic protections, such as having a proper placement within a community-based program or their families before we launch them into a legal process. It also draws attention in the adjudication process such that it empowers a child, that we care about their experience, such as the recommendation that we make in stage 4, where we will ask questions of a child in a manner that isn't emotionally taxing on them, that it isn't repeated questions from different case managers and attorneys and trial attorneys, but rather that it focuses on gathering information from a child in a way that it is safe for them and that it gets them to talk about it one time and it doesn't re-traumatize the child. In my experience as an attorney, by the time I met a child, or by the time I had interviewed them multiple times to present a declaration or complete an application, I found that they were tired of being asked the same questions by the time I came around. And some of them would stop talking altogether about their story, or would just simply shut down because they've had it by the time they met me, and maybe they had been in other prior placements. And also imagining such a manner of gathering information for children also reduces the likelihood of there being records that are conflicting that get created along the way. So that's another benefit that I see as an attorney from that perspective as well. And it also is a system that shifts the question of safety to the forefront of the inquiry, rather than after the fact, after an order is issued. So before an immigration judge makes a decision of whether a child should be removed, first we ask if issuing that order is an order that is going to align with the child's safety, as opposed to issuing a removal order and figuring out a way to make that repatriation safe for the child. From an advocate and attorney perspective, I love that it asks the question of, is the child be safe before a removal order would be entered? I also like the recommendations around how we wouldn't begin to have immigration hearings or the immigration process happen while we're focusing on finding a placement for the child. In other words, that nothing legal will happen while the child is in custody. And I love that because it allows us to focus, when a child is in custody, it allows us to focus on finding a placement for a child, a safe place. And where we don't have a situation where a child is stressing while they're in detention, or even being threatened while they're in custody, that if they misbehave or say anything in the shelter, that is going to be used against them in the removal proceedings. And I also like that it allows a child about 3 months for them to be adjusted in that placement, whether it be a community-based care program or a placement with family, before they have to start going to immigration court. That allows them to assimilate in that new placement. And I also like that it enables us to be able to grant best interest protective status. And I like that because it allows us to focus on a child for their strengths, for their progress, and for the flowering of that child while they've been in custody, and not just focus the inquiry on whether they've been persecuted, on whether there are deficiencies or abuse in their past. It allows us to also focus on those other things. It enables us as immigration attorneys to go after forms of relief that are part of the system now, but it also asks us to focus on a different question as well, if those traditional forms of relief cannot be obtained. I think that for children overall, this reimagined system is one that honors them, that honors their voice, that honors their needs, that honors their interests, and not just a system that is focused on governmental interest as we are now, and that it provides timeframes that are child-friendly, that are centered on the child, and not timeframes that are centered on political agenda sometimes about how fast children should be removed, or the cost that it may have for the government. So those are my observations, and I know that there are others who are listening to us today who are also immigration practitioners and represent children. And during the Q&A period, I would love to hear any observations that other practitioners may have as well.
Thank you so much, Gladys. Thank you. So now I'm going to turn it back to Jennifer, who will facilitate questions if we have questions, and you can type them into the chat box, and we will forward them to somebody who can answer your question. Thank you.
Thanks, Maria. We've already got several questions, so we'll do our best to answer those and get to any remaining that pop up. The first question is whether or not trauma-informed practices are integrated into the roadmap. And yes, they are. Thank you for that question. The roadmap requires, and again, the roadmap is sort of the first step. Despite the 99 pages, it doesn't go into nearly the depth that we would want to have in a completely developed system. But at the very least, the roadmap requires training in trauma-informed practices for everyone who works with children, not just child advocates and attorneys who do have that kind of practice and training these days, but also judges, asylum officers, even government attorneys. I would argue that government officials do as well. For the last several months, we have been dealing with children who are in the process of being returned to their country of origin. Some of them are kiddos who've been separated from family members for quite some time. And the amount of work that my colleagues in the Child Advocate Program have to do just to persuade the officer accompanying the child on the flight home not to wear a uniform, not to display a weapon if they're carrying one, to be attentive to the child's trauma history so that a child is accompanied by an adult of a gender that they are comfortable with. We engage in extensive advocacy around that, and that should really be something that doesn't require advocacy, where everyone in the system has sufficient training to recognize what children need in order to feel safe and comfortable at all times. Another question we got is whether or not we could say more about Indigenous children. So I'll say a word or two from the perspective of the framework, and then Gladys or Maria or Elvis, if anyone else wants to jump in, please feel free to do so. The system that we have is at best designed around the needs of Spanish-speaking children. And they do form the majority of children who come to our borders. But children come to the United States seeking protection from all over the world. At the Young Center, we've served children, I believe, from more than 80 different countries. Children from indigenous communities, though, in Central America have unique challenges. And one of the greatest of those is they are assumed to understand Spanish. And because of that, so much vital information about them is missed. One of the very first kids that I was appointed to at the Young Center was a 16-year-old boy from the highlands of Guatemala who spoke Mam as really his first and only language. But a year earlier, before he had come in to the immigration system, when he was just 15, he'd actually been charged in federal court as an adult male from Mexico. He had been picked up near the border with a group of other men. And every time somebody from immigration or law enforcement said to him in Spanish, "Entiendes?" meaning, "Do you understand?" He'd say, "Sí, yes." It was all he knew how to answer. And so despite the fact that he was a 15-year-old child trafficking victim from Guatemala who only spoke Mam, he was charged in federal court as an adult male from Mexico. And I think those are the kinds of situations you encounter when we don't meet children where they are, where we don't have spaces to say, what is your best language, and to explore that with them fully until they've had a chance to offer all possible explanations. Gladys, I see you turned your camera on. I didn't know if you wanted to weigh in on this.
Well, Jennifer, just agree the importance to provide that space for kids to talk about their needs, linguistic and otherwise, and to tell their stories.
Another question we got was on how a system under the roadmap, how the roadmap would address issues of accountability, especially if ultimately kids are having their cases adjudicated in conference rooms instead of public courtrooms. It's a phenomenal question. That's one of the places where we have to dig in with advocates in the field like Shana, who asked the question. I turn around and ask it right back to her because I think she'd have a terrific answer. But I think a couple of things that come to mind are there are ways to hold systems accountable. I think, unfortunately, in the last 4 years, we've seen a tremendous undermining of those mechanisms, but they exist. One of them is strong oversight from Congress and from independent watchdog agencies. For the last 4 years, a lot of federal agencies have rebuffed, refused to answer, ignored, or only held confidential briefings with members of Congress who had real questions about family separation, about the border closure, and about other treatment of migrant children. That has to change, and I think that could change. And when that sort of oversight is written into law, as opposed to just routine practice, it becomes a lot more powerful of a tool. I think the other mechanism for accountability, in my experience, both child advocates and lawyers for kids are incredibly zealous advocates. And in a world in which decision makers had to consider best interests, I think both child advocates and attorneys would fight to make sure that that happened. It's a lot easier to do that when there's a clear prohibition against any sort of limitations on advocacy because of where funding comes from. And as Maria mentioned at the outset, this reimagined system will require funding in different ways. And I think one of the ways that funding needs to change is making sure that lawyers and child advocates are free to advocate for what they want as zealously as they are able to do so, whether it's in individual cases or with respect to policies and procedures, for example, issues of reproductive health. Child advocates and attorneys need to be able to do their job. And that's one of the mechanisms for oversight that we could benefit from. We had another question about how frustrating it is to find out what's going on with kids and to stay on top of these issues, and whether or not there's a listserv or an e-newsletter or something to subscribe and keep us up to date. And because I'm not celebrating me, but my colleague Noor Jahan, I will just say the Young Center puts out social media content on a daily basis about everything that's going on with respect to immigrant kids, and not just unaccompanied kids, but the incredible folks over at United We Dream who have been organizing around Dreamers and DACA recipients. We keep that as up to date as we can, and we link both to community-based organizations doing the hard work in communities, but also academics and think tanks. So I would follow the work that Noor Jahan puts out on the Young Center social media as a great place to stay on top of those issues. And I'm sure we can put in the chat links to where you can find us on social media. Another question, and Maria, I'll start it, but it'd be great if you want to chime in as well, and maybe it's a good place to start to wrap up. We have a question about how do we make this a reality? Well, we thought putting out the report would be a good first start. At the very least, it lets those of us in the advocacy community start to have some hard conversations. Not everybody is going to agree that these proceedings should take place in conference rooms rather than courtrooms. Not everybody will agree on whether there should be one adjudicator of children's claims or multiple adjudicators. We can start to have those conversations now. We can start to draft language that could be incorporated into statute or regulation now. And we have friends on the Hill who are very interested in these issues. But the reality is, to make this happen, because it requires change in law, we need people in Congress and in the administration who have that same desire to make change. And I think we will need that to happen at some point in order for this to become a reality. Maria, is there anything you want to?
Yeah, I mean, yeah, I was actually going to say, I mean, I think we need people's support. I think we need help from all corners in their ways for everyone to get involved. We need the public. Your voices are important. We won't be able to make change without public support. We will absolutely need our sister organizations to work with them alongside each other. We'll need help from community-based organizations. We need activists. We need retired immigration judges, retired enforcement officials to lend their voices. And probably most importantly, we need the help of young people to make this a reality. This is going to it's going to be a collaboration, and we really welcome your help.
Marie, we do have one more question. That was a really nice way to end, but I mean, since we have another question, I'm going to go ahead and field it. And Mary in Virginia noted that in Virginia courts, she's repeatedly heard a presiding judge say that his job is to ensure that the United States acts in the best interests of the child. So that is the mandate in state child welfare proceedings. It's not the mandate, at least under the written law in immigration courts. If you're hearing that in immigration court, I am thrilled to know it. And I would like to think that maybe this is a judge who's receiving our best interest recommendations on a fairly regular basis. And to be honest, I think the reason we get judges and asylum officers asking for best interest recommendations is because they really do want to know. A lot of them really do want to know what happens to a child as a result of the decisions that they're making. And I think that they recognize that the kids in front of them are not the same as adults. And I think they want laws that they can follow that allow them to treat children differently. And they know, especially if they have practiced in other areas, they know that that is the standard when children are before judges and other decision makers, that their best interests are a part of the decision making. So I think what we are trying to do with this is sort of build the scaffolding to create laws that would give judges the obligation that some of them really want to have, which is to always be considering the child's best interests in their decisions. I think I'm trying to scroll through the question, but I think that's about all we can get to at the time that we've got. We just want to thank, there were so many people here tonight, and you spent the whole time with us. We're so very grateful. You can find the full report if you're a glutton for punishment on our website, but we also have an executive summary if you want the short version posted to the website, both in PDF format, and you can just read and scroll through the text and photos to get the executive summary there. You can always contact us through social media, and I think that's where we are. If we didn't get to your question, we will respond by email. And again, thank you all so much for being with us tonight.